few people coming in, Mr. Jordan.
May it please the court. My learned friend began his submissions on abuse by saying a layperson would think something had gone wrong if VACAR is allowed to rely on an adverse possession claim in the light of what he said to Mr. Jarvis in 2012. In response to that, my submission is, if he read Judge Gerald's judgment, no doubt he would. If he read Mrs. Justice Bacon's judgment, she wouldn't. And in any event, that's not the right question. Lay people have adverse reactions to judgments of the courts all the time, and the courts can't be guided by that, but have to be guided by legal principle. Can I begin with the pleaded case on this point, which is in the core bundle at tab 30, page 355. Core bundle tab 30, page 355. We did look at this yesterday for a different point, but this is the reply and defence to counterclaim. Paragraph 8 pleads what Judge Gerald called the critical exchange, where VACAR said, how can you make an adverse possession claim on a property that you partly own? And the judge said, you cannot. Then off we go on to page 361. Paragraph 26. This is the case that was pleaded on this point. The second defendant is stopped and or otherwise barred from alleging that he has any rights in the flat arising by way of adverse possession in circumstances in which, as pleaded in paragraph 8 above, the second defendant expressly disavowed any rights in the flat arising by way of adverse possession during the course of his submissions to Mr. Jarvis on 16th February 2012, and Mr. Jarvis QC relied upon that disavowal in refusing to lift a stay on the first English action, as is apparent from paragraph 130 of the 2012 judgment. Those were the facts that were pleaded, and those were the only facts that were pleaded. It was not alleged that VACAR had engaged in a dishonest course of conduct designed to mislead first the trustee in bankruptcy and then the judge, which were important factors that Judge Gerald took into account in reaching the conclusion that he did, that it was an abuse of the process of the court for VACAR to rely on adverse possession. There was no suggestion that a duty arose on VACAR to correct an error when the learned judge was giving an extempore judgment after the hearing. I will come back to the significance of what was pleaded and what was not pleaded later. As far as the law is concerned, before Mrs. Justice Bacon, it was common ground that the principles stated by Sir Christopher Floyd in the LA Micro case were applicable here. My learned friend hasn't said that the decision of the Court of Appeal in that case was per incuriam, and it wasn't. It sets out the principles to be applied in a case like this, where the party says that the other party cannot put forward a particular case because of the stance they took in previous litigation, and there really is no need to look elsewhere. One or two points on LA Micro. My learned friend showed the court most of the passages that I wanted to refer to, so I won't go back to those. But there are just a couple of others I would like to show the court. So that's in tab Authorities, Volume 2, tab 49. My learned friend explained what was happening here. There was a dispute about the ownership of shares in an English company called which was referred to as UK. And in the first action, an American gentleman called Frankel said he personally had a 25.5% shareholding, and Mr. Bell said no, an American company called Inc. has a 51% shareholding, and any interest you have is derived through your shareholding in Inc. And that related to when the joint venture began in 2004. And Amanda Tipples, as it happens, sitting at that time as a Deputy High Court judge, ruled in favour of Mr. Bell and said the original agreement had been that Inc., the American company, would have a 51% shareholding. And then a few years later, in 2020, Mr. Bell started a new action in which he said that the two issued shares were owed as to one by him and as to the other by the other American gentleman, Mr. Limpierd, which was obviously a different position to the one he'd taken in the first action. And he said that was because there'd been a change in 2010. He said something had happened in 2010 where Mr. Frenkel had disclaimed all interest in the shares, and that had changed things. And the reason it was said that his stance in the first action was inconsistent with his stance in the second was because there had been documents and evidence about the position after 2010 in the first action. If one looks at page 343 of the law report, just one example. At the bottom is paragraph 16. In 2012, Mr. Bell was asked who the owners of UK were. He said the owners, so far as I understand it, are myself, Mr. Limpierd and Mr. Frenkel. In the 2015 proceedings, Mr. Bell was asked about that statement and he corrected it, saying he should have said they were owners via Inc. And then in the next paragraph, in a letter dated the 31st of August 2016, in the course of the 2015 proceedings but before the trial, Mr. Bell's and UK's then solicitors wrote to Mr. Frenkel's solicitors saying Mr. Bell believes that LA Micro is the correct legal and beneficial owner of 51% of the shares. So that was completely inconsistent with his stance in the second action. Sir Christopher Floyd said, as the court has seen, the principles to be applied were to be derived from the Cock-Hoon case in the Privy Council and the decision of the American Supreme Court in New Hampshire and Maine. And in paragraph 24, as the court saw, one of those points is a party's later position must be clearly inconsistent with its earlier position. That is obviously right. And he also said the court may inquire whether the party has succeeded in persuading a court to accept the party's earlier position, so that judicial acceptance of an inconsistent position in later proceedings would create the perception that either the first or the second court was misled. And then it's relevant to see how he applied that in the LA Micro case itself. Without going through it all, what he did was he examined the evidence in paragraph 28 and following. And at the bottom of page 346, at the end of paragraph 29, the last 4 lines, he said, although Mr. Bell's credibility may have been enhanced by the position he took, it is not possible to say with anything approaching confidence that he won before Miss Tipples on the footing of or because of the position he took in relation to the continued ownership by Inc. And over the page at the bottom of page 347 in paragraph 33, he said the suggestion that Mr. Bell and UK succeeded in the 2015 proceedings in relation to the terms of the 2004 agreement because of the stance which Mr. Bell took on the continued ownership of UK after 2010 seems to me to be far-fetched. So in reaching conclusions on this, Sir Christopher Floyd analysed the evidence and applied the principles. What he didn't do is say, well, this has already been looked at by His Honour Judge Jarman at first instance, so what I need to do is conduct a very delicate review of whether he balanced things correctly. And I'll come on to why that is the right approach in a moment. We are dealing here with a principle that shuts somebody out from advancing a case in court. In this case, a case which was tried at the same time, the actual claim to adverse possession, and which ought to have been decided in Vacar's favour. So it is a strong thing to do, to shut somebody out from the court. And if we can go back to tab 48 in the authorities bundle. This is a case called Koza and Koza. It's a convenient place just to pick up a point that I've made in our skeleton. At page 188 in the judgment of Lord Justice Popplewell, paragraph 33, he's quoting here from Henderson and Henderson, and he first at paragraph 32 quotes the authoritative modern statement of the principle to be found in the speech of Lord Bingham, which is well known. But he also quotes at paragraph 33 what Lord Millet said in a concurring speech, and he said the purpose of the principle was to bring finality to litigation and avoid subjecting a defendant unnecessarily to oppression, but went on to emphasize an important difference between cause of action and issue estoppel and the Henderson principle. May I ask the court just to read that paragraph, please?
Certainly.
And he applies that principle on page 194 of the judgment, in paragraph 43, just above letter H, where he says the first critical question is whether the injunction application should have been brought before Mr. Spearman QC. If it should, then I would regard the bringing of it in a separate and subsequent application as an abuse. If, however, it cannot be said that it should have been brought, then I would not regard it as an abuse, given the important Article 6 rights of access to justice emphasised by Lord Millet in Johnson and Gore Wood, unless it amounts to an abusive collateral attack on the Court of Appeal decision. So one has to exercise considerable caution before shutting somebody out from a court on the basis that something they have said either outside court or inside court. In terms of the other decisions that my learned friend referred to, the Gandhi case was considered by the Court of Appeal in LA Micro, so that can't be said to be inconsistent or to add anything to the principles stated in LA Micro. The Bradford and Bingley case is a decision of the Court of Appeal and not referred to in LA Micro, and therefore it is worth looking at. That's in volume 1 of the authorities at tab 14. My own friend said it wasn't important because in that case it was held that the principle didn't apply, but it's just as helpful to look at cases where the court says the principle doesn't apply as those where it says it does, when one's trying to work out what the principle is. This was the case, as my learned friend said, where a claim was brought against a Mr. Hancock, the negligence and claim on a contractual indemnity, and it was brought against him personally. And then some years later, a claim was brought against him together with his two partners in the firm of Hancocks. And the judge from whose appeal the appeal was brought held that that inconsistency was abusive and struck out the claim against Mr. Hancock on the basis that he'd already been sued in a personal capacity. It was inconsistent to sue him again in a different capacity. If one looks at page 1488, letter E, see what Judge Kershaw QC held. He said, just below letter E, Mr. Hancock had acted as a Mr. Hancock had acted as a member of the firm or in a personal capacity, nor did they change the fact that he had previously claimed against Mr. Hancock in his personal capacity, not as a member of his firm. He held, seemingly on the basis of his initial finding of inconsistency, that the third-party claim was an abusive process and therefore struck it out. And then if we go on to page 1429, so 1492, 1492, please, letter H. Lord Justice Auld there says that mere relitigation in circumstances not giving rise to cause of action or issue estoppel does not necessarily give rise to abusive process. And then on the next page, at letter B, he says some additional element is required, such as a collateral attack on a previous decision, some dishonesty, or successive actions amounting to unjust harassment. And then on page 1479,
97.
I think I mean 1497, my lady. Yes, thank you. 1497 at letter H. Lord Justice Auld said that the inconsistency, as the judge regarded it, was between Mr. Seddon's pleading in paragraphs 4 and 6 of his particulars of claim in the Preston action as to the personal nature of Mr. Hancock's indemnity and advice, and that in his third-party claim against the three partners, including Mr. Hancock, in respect of the same matter. In my view, that was a possible but not a necessary construction of the pleading and of the district judge's order based on Mr. Hancock's admission. So the word necessary is a strong word and indicates in my submission that Lord Justice Auld thought that before there could be inconsistency, there had to be clarity in the original statement that was said to be inconsistent with the current action. And at page 1498, the next page, between letters D and F, if I could ask the court to find at letter D, please, the sentence beginning, in my view. Could I ask the court to read from there to the end of that paragraph, please?
Sorry, the page again.
It's page, the bundle number is page 225, the court report page is 1498. So that again emphasises the need for great caution when applying a principle that shuts somebody out from the court because of a stance they have taken in previous litigation. So what should the approach of the appeal court be? In my submission, in a case like this, it is the approach taken by Mrs. Justice Bacon. Not in every case, but in this case, this sort of case. The leading case on this point is at tab 27. This is the Aldi Stores and WSP Group case. And this was a case about whether it was an abuse for a claim to be brought when it could and arguably should have been brought in earlier complex multi-party litigation. And the answer was no, it wasn't an abuse. And Mr. Justice Jackson had been in error in saying it was. And at page 762 of the law report, page 589 of the bundle, Justice Thomas stated the approach of an appeal court in paragraph 16. May I invite the court to read that, please?
Certainly.
So in a case where there are a number of factors which have to be considered and weighed and balanced against each other, some factors point one way, some factors point the other way, and the trial judge has undertaken an exercise of weighing and balancing them, the appeal court will be reluctant to interfere and will generally only do so in circumstances described there. But there was no balancing of factors by Judge Gerald. He didn't say, on the one hand, I'm taking into account this point, on the other hand, I'm taking into account this point, and balancing them all together, I come down to this conclusion. There was nothing of that sort in his reasoning. And can we ask the court also please to look at page 766 of the report?
Is that really though what Lord Justice Thomas then was meant there? He's saying he is comparing a discretion with a conclusion which is either right or wrong about whether there is abuse or there is not abuse. And when reaching a conclusion about whether or not there is abuse, there are many, many different strands to be taken into account and weighed, if you like. He's not saying, and so he's saying he's explaining what kind of decision making it is. He's not saying, oh gosh, you've got to have the balance, you've got to be able to show, you know, what you've done with this and what you've done with that. It's a different kind of, a different kind of explanation he's giving at paragraph 16, which feeds into what's been said in a number of cases, which is this is a broad-based conclusion to be reached on in all the circumstances, on all the facts.
Indeed, that's what Lord Justice Thomas was saying in the context of a case where that was an appropriate thing to say.
Yes.
I'll come on to another case where it wasn't and where the Court of Appeal took a very different approach. But in this kind of case, then yes, my lady, that is of course right. May I draw attention also please to what Lord Justice Longmore said on page 766 of the law report, paragraph 38. It would be troubling if two different judges could come to different conclusions on whether the same facts constitute an abusive process and yet both be right. The other case, the one that I said I was going to come on to, is at tab 31. It's called Pickthall and Hill Dickinson, and we looked at it briefly yesterday for another point. This is the one where Mr. Pickthall thought he had a claim against his former solicitors, but he was made bankrupt. So his claim, if he had one, vested in the trustee, and he was hoping to get an assignment of the cause of action from the trustee. And I think on the last day of the limitation period, he issued a claim form to protect himself against the expiry of the limitation period. And His Honour Judge Waxman said there was no abusive process, but the Court of Appeal disagreed with that. And if I could ask the Court to look please at paragraph 13. The leading judgment was given by Mr. Justice Mann, sitting in the Court of Appeal, with whom Lord Justice Thomas and Lord Justice Laws agreed. And in Mr. Justice Mann's judgment at paragraph 13, he said that Mr. Flenley's first submission was that the determination whether there's an abuse was the equivalent of an exercise of judicial discretion, which should only be interfered with on the basis of the same basis as the exercise of discretion. And then there's a quotation from Lord Justice Thomas in Aldie. And then if I could ask the Court please to read paragraph 14. And it is perhaps reassuring that Lord Justice Thomas was a member of that court and agreed with that. So the Aldie approach is not applicable in all circumstances.
That's a very different question in that case than ours, isn't it? On the LA micro test, there is a range of factors to take into account. It's a broad evaluative process. Yeah. But in this, it wasn't. It wasn't an abuse to bring a claim when you haven't got the cause of action.
Yes. Well, even if the Aldie approach is appropriate, one can still criticise a judge and say that the judge got things wrong because they took into account things they shouldn't have taken into account, or the opposite, or they reached a decision outside the reasonable range, bearing in mind what Lord Justice Longmore said in Aldie, that it would be troubling if two different judges could come to opposite conclusions on the important question of whether conduct is an abuse of the process of the court. So I can ask the Court next to go to the core bundle, please. And Judge Gerald's judgment. I'm not going to spend a long time on this because it's been taken through this, I think, both by myself and by my learned friends in some detail. But nonetheless, I would like to go back to starting at page 237. I can deal with it in this way by looking at paragraph 100. And identify what in my submission, all of those factors which is referred to in the first line, taking all of those factors into account. What were they? In my submission there were 3 factors. The first factor was that Vacar had lied to the trustee in bankruptcy and was lying to the court when he said he had no interest in the flat. Vacar never believed that his father was the owner of the flat. One gets that from paragraph 87. So when he told the trustee in bankruptcy and Mr. Jarvis that he had no interest in the flat and his father was the owner of the flat, that was knowingly disingenuous and a masterpiece of dissembling and manipulation, i.e. a lie. And one gets that from paragraphs 89, 98 and 99. The second factor he took into account was that the reason, the motive that Vacar had for telling Mr. Jarvis that he did not think he was able to claim adverse possession was to persuade Mr. Jarvis not to lift the stay. The judge found that he understood in 2012 that if Vacar was arguing that if a new action was started, it would be met with an adverse possession defence, which would be prejudicial to Iftikhar. And that was the reason he told Mr. Jarvis that the adverse possession claims of the land registry had been a mistake, to try and dissuade Mr. Jarvis from lifting the stay by making him think that if there was a new claim, there would be no adverse possession defence. And one gets that from paragraphs 92, 94 and 95. And the third factor is that Vacar was good at saying things that communicated something different to the ordinary meaning of the words used. And therefore, although from the transcript it looked as though Vacar was asking for advice, in reality he was saying to Mr. Jarvis that if the stay was not lifted, and if at some time in the future any rights that were currently vested in the trustee in bankruptcy came back to him, he would not at that point advance an adverse possession defence in order to persuade Mr. Jarvis not to lift the stay. And one gets that from paragraphs 80 and 94. So I hope that without going through all the paragraphs again, that I can take matters in that way. The actual thing he said to Mr. Jarvis was, I think my learned friend's phrase was evasive and opaque. It wasn't evasive, but it wasn't particularly opaque either. He was saying, I don't think I can have an adverse possession claim when I say that I was a part owner of the flat as a member of the family partnership. That's what he said. And the judge said, yes, I agree with you, you're right about that. So Judge Gerald did not simply rely on the fact pleaded in the reply to reach his conclusion of abuse. He added in other factors, which I have identified. So as to what I conceded, my learned friend said I'd made a concession about Judge Gerald's findings. I did, and it's recorded correctly in Mrs. Justice Bacon's judgment at page 184. In paragraph 51, where the last 2 lines on page 184, Mrs. Justice Bacon said, Mr. Jordan rightly did not take issue with the judge's findings as to the credibility of character of Vacar, with related findings as to Vacar's understanding of what had been said at the 2012 hearing. So I accept that we are bound. Obviously we disagree with them, but we accept we are bound by what Judge Gerald said about Vacar's credibility as a witness and his character. And we accept we are bound by Judge Gerald's finding that he did understand that if Iftikhar was saying he would be prejudiced if the stay was kept in place and he had to start a new action, because then he could be met by an adverse possession defence. But what we did not accept, and what we do not accept, is that the judge was entitled to find on the evidence that Vacar had the subjective purpose of trying to persuade Judge Jarvis, Mr. John Jarvis, sitting as a Deputy High Court Judge, I should say. We don't accept that the judge was entitled to find that his purpose was to persuade him not to lift the stay. That is an absurd finding, a perverse finding, because very shortly after Vacar said, "I don't think I have an adverse possession claim," he said, "But my wife does." Just doesn't make any sense. If he was trying to persuade Mr. Jarvis there would be no adverse possession defence in a new claim, he would have said, "Neither of us will have one. Not, I won't have one, but my wife will have one."
That was a finding that was specifically appealed, was it?
My lord?
It's the finding of Judge Gerald that it was Vacar's intention to persuade Mr. Jarvis not to lift the stay. That's a finding he made. You say he wasn't entitled to make that. Was that something you appealed to?
Not as a discrete point, no. But our point was that what was said to the judge, taken as a whole, did not convey that message. I didn't specifically appeal from the finding as to what was in Vacar's mind, because it was our submission and is our submission that what was in his mind is immaterial. Something that Mrs. Justice Bacon thought was common ground, but now isn't, at least.
But just get this straight, I'm sorry to be clear about this. So you didn't appeal that finding of fact, but you appealed on the basis it was irrelevant, because what was in his mind was irrelevant.
Yeah. But if I have to live with it, I will live with it. But it doesn't make any sense. Paragraph 94 of Judge Gerald's judgment. It's not a primary finding of fact based on the evidence. It is an assembly of facts leading to a conclusion based on that evidence. So the submission I made to Mrs. Justice Bacon, which she accepted, was that it would be wrong to treat what Vacar said as giving rise to an abuse of the process of the court, unless what he said was clear. I did draw an analogy with promissory estoppel, and I maintain that that is a helpful analogy. It is right as a matter of principle that it can only be just to prevent a person from relying on their rights because of what have they said to somebody in the past, if that statement was sufficiently clear. It's not some arbitrary rule of law that applies to promissory estoppels and indeed all forms of estoppel for some reason lost in the mists of legal history. It's a simple element of basic fairness. Before you can be precluded from relying on your rights, whether they're contractual rights or property rights, or the right to come to a court and ask for your case to be heard, before you can be precluded from relying on your rights because of something you said, what you said should be clear. Promissory estoppel is an equitable principle developed by the courts by applying essential principles of fairness. And it's not rules-based. It's not like the res judicata estoppels, cause of action estoppel, and issue estoppel, which have a set of fixed rules. Promissory estoppel and proprietary estoppel, too, have principles which inform the approach of the court. And one of those principles is that for a statement to be operative, it has to be sufficiently clear. There was some discussion this morning about the position where somebody remains silent. In non-judicial estoppel cases, silence can generate an estoppel where there's a duty to speak. But normally, silence doesn't generate an estoppel because silence is inherently not clear. Sometimes it can be clear, and it will be clear if there's a duty on somebody to speak up and they don't. The proprietary estoppel if I see somebody building on land that I know is mine, and I know that they're labouring under the mistake that it's theirs, and I stand by and watch them build on my land, then a proprietary estoppel will prevent me from relying on my rights against them. It's clear from LA Micro that this is properly to be understood as an estoppel principle, although it is, like all equitable estoppels, one that's informed by essential principles of fairness. And my submission that I made to Mrs. Justice Bacon, and that she accepted, and I would invite this court to accept, is that no one who looked at what Vacar said, not only in the critical exchange, but very shortly afterwards about Syra, could possibly think that he was making a clear representation or a clear statement of any kind, that there wouldn't be an adverse possession defence in the new action that was contemplated if it might be starting. Can I just put what he said about Syra's position in context? If you could look in the supplemental bundle, please, at tab 7. This is the supplemental bundle, tab 7, page 77. So this is a letter from Weller's Law Group, and they were solicitors, and one can see from the heading, our client, Syra Malik, your client, Iftikhar Malik, and they were answering some questions, one of which was the basis on which Syra was opposing the application. And they said, amongst other things, our client is entitled to remain in occupation because she's been there for 30 years and has adverse possession rights. So it was known before the hearing that Syra had her own adverse possession claim. Any claim that Vacar had was vested in his trustee in bankruptcy, but Syra's wasn't. And the other factor that one needs to take into account when considering what was said about Syra is at tab 5 in this bundle. Page 61, this is the witness statement that Syra made on the 26th of May 2011. And if I could ask the court to look at the next page, page 62, and to read paragraphs 5, 6, 7, and 8, please. So Syra was saying two things. She was saying, I've been there for 30 years and I have an adverse possession claim. And she was saying, at the time of my marriage, I was promised by Bilal and Iftikhar that I could live in this flat as my home with my family for our lifetime. And that's the context for the exchange about Syra, which is quoted by Mrs. Justice Bacon in the core bundle at page 186.
Core 186.
186, please. So 186, we have the critical exchange between Vacar and Mr. Jarvis. And then if we turn over the page at paragraph 63, a few pages further on in the transcript, there was the following discussion as to the position of Sarah, not referred to in the judgment of His Honour Judge Gerald. My learned friend said Judge Gerald must have had this in mind. Well, he should have had it in mind because he was taken to it by counsel, Mr. Pettican. We said that in our original skeleton, and it's never been disputed that this was drawn to Judge Gerald's attention, but he doesn't refer to it. And it's an important factor which he did not take into account. So even on a multifactorial value assessment sort of basis, this is an important factor he did not have regard to. And the key part is when Vacar said, it's about halfway down the page, that if there was a new claim, well, she would be in a better position to deal with a new claim, because if it is still claimed that Iftikhar is the owner and that he bought the funds from his personal, then she would obviously, I suppose, have rights of adverse possession, Mr. Jarvis. But what will be claimed is, we know that your brother Iftikhar's case is, he says he is the owner, he is a registered owner, and he's entitled to possession. It will then be up to your wife to plead her defence to it. She's not pleaded defence yet, so it will be exactly the same as it would in the present action. Mr. Malik, yes, but there would be a slight difference, would there not? The difference would be, and I'm not suggesting that she is, that because she was not a partner in the business, then it may well be possible that she has a defence regarding adverse possession, for the simple reason that she's been in occupation for that many years, and Iftikhar has done nothing about the claim that he filed earlier on. The Deputy Judge, you cannot claim adverse possession when you have that sort of promise. You do not get title from that. You have been given a right to live there on certain terms. He's clearly there referring to what Sarah said in her witness statement that the court's just seen. Mr. Malik, yes, but that would only apply if the file, that must be if Iftikhar. If Iftikhar were to concede, and there is no bar in English law which says the father had the authority to decide, because Deputy Judge, her evidence is that Iftikhar agreed as well. So what happened there was that Vacar said to the judge, if there is a new claim, you can expect that my wife will be making an adverse possession claim. And at this point he was speaking on her behalf, which the judge had with some reluctance allowed. And her solicitors had said that she was going to claim adverse possession in a letter before the hearing. And it's not Vacar disavowing an adverse possession defence, it's exactly the opposite. And what's happening here in my submission is that the judge had taken the view of the law that my learned friend invites this court to take, which is that somebody who believes they have the permission of the owner to live in the property, and then unless it's a tenancy, they don't have the intention to possess. That would explain the judge's reaction to this point. My learned friend said that this is island hopping, but it isn't. It's not island hopping to draw attention to an important part of the evidence that the judge has not taken into account, and that if taken into account, compels a different conclusion. It's not the case that this court can never review findings of a trial judge. My learned friend at some point seemed to be getting close to saying there can't be any appeals except on points of law, which isn't right. But in any event, it is an error of law not to take into account a material fact. And judicial reviews can be mounted on that basis. My learned friend says, well, it doesn't matter what was said about Sarah because she in the end didn't make an adverse possession claim. But that is not relevant. What is relevant is whether it was a reasonable, permissible assessment by the trial judge that, taking the evidence into account, there was a clear statement to Mr. Jarvis made by Vacar that there would be no adverse possession claim if the stay stayed in place and a new possession claim was started. He didn't say that, he said the opposite. So what about paragraph 130 of Mr. Jarvis, where he said that Sarah and Vacar had confirmed that there was no claim for adverse possession? Well, in my submission, anyone who had been present at the hearing or who read the transcript would understand what he meant by that. He was giving an extempore judgment, and what he meant by confirmed was he meant that Vacar had confirmed that he understood and accepted the judge's decision on the point, that it wasn't going to be open to Sarah to take an adverse possession case in the future. And as far as Vacar himself was concerned, that the judge agreed that he didn't have any right to adverse possession based on the fact that he had maintained that he was a part owner of the flat. So there was no reason for anyone to correct anything in the course of the giving of the extempore judgment. was everybody who was present knew what had been said. They knew it wasn't the case that Vakar and Sarah had stood up and said, "We confirm that in the future there will be no adverse possession claim." They knew that what had happened is Vakar said, "Well, I don't think I can, but I think my wife can." And the judge had said, "I don't think you can't and your wife can't." And in any event, Mrs. Justice Bacon was surely right that it was unrealistic to expect one line in an extempore judgment to be corrected by those present. So in my submission, the learned judge who this appeal arises from, Mrs. Justice Bacon, approached the point in the right way and made the right assessment and reached the right conclusion. Then we have points raised by respondents' notice.
Before you go on to that,
Yeah.
Mr. Mundy fairly raised the point about him having conceded the test, that is, there must be an express statement.
Yes.
What do you say about that?
Well, it's my understanding that if a concession doesn't influence the course of evidence and relates to a point of law, then unless it's possible to point to prejudice, the court will allow the concession to be withdrawn. I'm not in a position to say that I'm prejudiced.
It's very helpful.
So yes, we have additional points, that some of which the learned judge considered and rejected, and one of which she didn't discuss specifically, didn't make a finding on specifically. The first one I will take quickly, which is that Vakar's statements did not secure for Vakar a result, which might otherwise not have been achieved. My submission is, was to Mrs. Justice Bacon and is to this court, that when you're dealing with judicial estoppel, the question ought to be the statement that was made to the court that is said to generate the judicial estoppel. Did it secure for the party who made it a result that might not otherwise have been achieved? If it's unclear whether it might or might not have been made a difference, then I accept the court can't go back and remake Mr. Jarvis's decision. But if it is clear that there was a right answer, then because we're talking about the court, that right answer ought to be applied. In a case about the boundary of the river in North America, there is no clear right answer. But if the court can see, well, even if that had not been said, the result was inevitable anyway, then in my submission it would be wrong to deprive a party from advancing a case in a new claim. And my submission, I'd made the submission yesterday and I won't go through it again, is that if Mr. Jarvis had appreciated that there was going to be an adverse possession claim, and that it was at least arguable that the limitation period had expired, and therefore adverse possession could be relied on by the trustee in bankruptcy or Sarah or both of them in the new claim, that would have been a factor in favour of refusing to lift the stay for all the reasons that I explained yesterday, because under the Burkitt and James Arbuthnot principles, once the limitation period has expired, then the person who has been guilty of inordinate and excusable delay, which has increased and created a position where a fair trial is going to be difficult, ought to be left to face that limitation defence in a new claim and not spared from it. The next point that I raised by way of respondent's notice, which the learned judge didn't deal with in terms, was that His Honour Judge Gerald based his decision on a critical assessment of Vakar's character and indeed actions in finding that he'd lied, which wasn't open to him. I did submit to the learned judge that these matters were irrelevant, and she agreed with that, and I repeat that submission. But if they are relevant, if they are matters that the judge was entitled to take into account, then they had to be pleaded, and they weren't. Before I turn to authorities, can I say what, in my submission, the law is, and then try and make that good by reference to two cases, as to when dishonesty can and can't be taken into account if there's been no pleading of dishonesty. First situation is where dishonesty is relied on as a fact or a factor to secure relief that's being sought from the court. It's something that's being identified that the court ought to actually take into account in deciding if a cause of action is satisfied, or in the case of a multifactorial assessment, one of the factors to be included in the balancing exercise. In that case, you have to plead dishonesty because it is a fact you're relying on. And pleadings are supposed to set out the facts you rely on. The other situation is where dishonesty is not a fact or a factor, but it is relevant to the assessment of the credibility of a witness's evidence. There is no requirement to plead it because you plead facts. You don't plead how you're going to invite the judge to treat the evidence of a particular witness. If one takes fraudulent misrepresentation, for example, if you want to claim relief for a fraudulent misrepresentation, you have to plead that the representor knew that the representation was false or was reckless as to whether it was true or false. You don't do that, you can't invite the trial judge to find that the representation was made fraudulently. But you can invite the judge to say that the representor was a liar and the judge shouldn't believe a word that the representor said in the witness box. That's the distinction. And to make those submissions good, can I look first of all at Three Rivers District Council, which is in the Authorities Volume 1 at tab 20. There were a number of issues in this appeal to the House of Lords. One was what the ingredients were of the tort of misfeasance in public office, and the House of Lords held that required bad faith, either knowledge or reckless indifference to the illegality of the official's act. Another, and this is the relevant one, was whether a proposed set of amended particulars of claim disclosed a reasonable cause of action for misfeasance in public office. And that is the context in which the members of the Judicial Committee discussed the rules on pleading dishonesty. And if I could ask the court to look at page 268, which is 374 in the bundle. This is in the speech of Lord Hutton, who was in the majority on the issue of whether the pleading was sufficiently clear. Lord Stein agreed with him. Can I ask the court, please, to read paragraph 122? There is a great deal more in the judgments to the same effect. Just for the court's note, Lord Hope dealt with it at page 249 in paragraphs 52 and 53, and Lord Millet, page 291 at paragraphs 183 to 187. But it's probably enough for my purposes to note what's said just above letter H. An allegation of dishonesty must be pleaded clearly and with particularity. So that's my support for the first submission. The second proposition is illustrated by a case cited by my learned friends in their skeleton argument, which is in the Authorities Volume 2 at tab 44. The judgment of Her Honour Judge Melissa Clark is a good illustration of the principle that picture is worth 1,000 words, because if the court looks on the third page, page 993 of the bundle, just above paragraph 4, this is what the case was about, whether there was breach of copyright in the logo on the left by the logo on the right. Perhaps the court can guess what the answer was.
Very dangerous, that.
The relevant part of it is on paragraph 15, where the law is explained. Page 997 of the bundle, paragraph 15. The judge said it's common ground, but an essential part of proving copying is an unbroken causal connection between the original work and the infringing copy. Causal connection can be either direct or indirect. A prima facie case of copying may arise if there is substantial similarity and proof of access to the original work by the alleged infringers. And then the issue of dishonesty is dealt with at paragraph 23, on page 1000 of the bundle. It was being submitted by the defendant that it wasn't open to the judge to find deliberate dishonest copying when that hadn't been pleaded, and the judge rejected that. And in paragraph 23 she says that his submissions amount to a submission, but unless a party pleads dishonesty in relation to witness evidence, both the party and the court must be taken to accept that the witness has given that evidence honestly. That is not correct. And then she gives a number of reasons. So that's an illustration of the second proposition, that you don't have to plead that you believe a witness who's going to be called by the other party is a liar. You're perfectly entitled to make that submission in closing after you cross-examine them. But what you can't do, as the Three Rivers case makes clear, is rely on dishonesty as an essential element of the relief that you're asking the court to give you. And what His Honour Judge Gerald did was to make an assessment that Bakar had lied to the trustee in bankruptcy and was lying to Mr. Jarvis, and to take that into account as a factor, clearly an important factor, in his assessment of whether it was an abusive process for Bakar to rely on adverse possession in the 2017 claim, and he wasn't entitled to do that because it hasn't been pleaded. The other points that we've taken by way of respondent's notice I will deal with briefly. The first is if this was a multifactorial value assessment which required taking into account different factors and weighting them. And one important factor was that if, contrary to Judge Gerald's view, Bakar had been in possession of the flat, then the result of preventing him from advancing an adverse possession case was that he would lose a valuable flat, lose his rights to a valuable flat. And the policy of the Limitation Act that produced that result. He doesn't mention it, and it can't be assumed that he took it into account if it was an important factor and he doesn't mention it. My submission, the right inference is that he didn't take it into account. Mrs. Justice Bacon said it was fanciful that the judge ignored the consequences, but it isn't fanciful to say that if a judge writes a judgment telling you the factors they've taken into account, but those are the factors they've taken into account. And if they haven't mentioned something which is in fact a very important factor, it'd be wrong in my submission to say, well, their decision should be treated as impeccable because they've taken all the factors into account. And the final submission is that even if none of my submissions individually is enough to persuade the court that Judge Gerald was wrong and Mrs. Justice Bacon was right, nonetheless, if you take into account everything, the decision he reached was outside the ambit within which a reasonable disagreement is possible. It was perverse. And that is something we said. The overall assessment was wrong. The learned judge didn't say that that was right. She just said she'd reached the decision that he was wrong on a narrower basis. But I do invite this court, if the court is against me on everything else, to uphold her decision on that basis. So unless I can assist the court any further on abuse of process.
No, thank you very much.
I'm going to turn to adverse possession. My learned friend said adverse possession is receding into the distance, which may come as a surprise to the judges of the Land Registration Division of the Property Chamber of the First Tier Tribunal. There are still many adverse possession cases brought under Schedule 6 of the Land Registration Act 2002, where adverse possession for 10 years entitles one to apply to be registered as proprietor. Then the registered proprietor can serve a notice saying they want paragraph 5 to apply. And if that happens, then there are only 3 limited grounds on which the claim can succeed. But registered proprietors don't always serve the right notice. If the registered proprietor dies, then personal representatives, unless they become registered as proprietors, can't serve the notice. And adverse possessors do sometimes say that one of the three factors in paragraph 5 are made out. So there are still a lot of adverse possession cases, and therefore it is important that the law remains sound. So I will take a little time on this. It's important to this case, and it's important more generally. You can look in Authorities Volume 1 at tab 24. Please, back at Pye and Graham. And page 434 of the law report.
I'm sorry, I missed that page because I'm
Sorry, my lady.
reconstituting my bundle. Yes.
It's tab 24, page 434 of the law report, page 532 of the bundle.
Thank you.
This is in a speech of Lord Brown Wilkinson. And at paragraph 35, he explains that from 1833, old notions of adverse possession, disseizin or ouster from possession should not have formed part of judicial decisions. From 1833 onwards, the only question was whether the squatter has been in possession in the ordinary sense of the word. That is still the law, as Mr. Justice Slade rightly said. And then in paragraph 36, he says, many of the difficulties with these sections, which I will have to consider, are due to a conscious or subconscious feeling that in order for a squatter to gain title by lapse of time, he has to act adversely to the paper title owner. He has said he has to oust the true owner in order to dispossess him, but he has to intend to exclude the whole world, including the true owner. But the squatter's use of the land has to be inconsistent with any present or future use by the true owner. In my judgment, much confusion and complication would be avoided if reference to adverse possession were to be avoided so far as possible, and effect given to the clear words of the Acts. Which is unfortunate, because all judges, when discussing this subject, do refer to adverse possession. But Lord Brown Wilkinson said it was unfortunate that that phrase had been introduced into the law in 1939, and it shouldn't form any part of the assessment. The question, he said at the end of paragraph 36, is simply whether this defendant squatter has dispossessed the paper owner by going into ordinary possession of the land for the requisite period without the consent of the owner. Paragraph 37, it is clearly established that the taking or continuation of possession by a squatter with the actual consent of the paper title owner does not constitute dispossession or possession by the squatter for the purposes of the Act. Beyond that, as Mr. Justice Slade said, the words possess and dispossess are to be given their ordinary meaning. And what Lord Brown Wilkinson is referring to in paragraph 37 is what might be called vicarious possession. It's the one situation where possession in the Limitation Act doesn't have its ordinary meaning. If you find a tenant in possession of land which his landlord does not own, so the landlord has either deliberately or inadvertently granted a lease of land that the landlord does not own, then as between landlord and tenant, the tenant is in possession. The tenant has the right to exclusive possession for the term of the lease, as against the landlord. The landlord can only go on the land if he's reserved rights to do so in the lease. So in the ordinary use of the word, the tenant is in possession of the land and the landlord is not. But under the Limitation Act, it is the landlord who is in possession through his tenant. The tenant's possession is said to be on behalf of the landlord. And in this situation, time will run in favour of the landlord, and at the expiry of a 12-year period, the landlord and not the tenant will be the one who will be entitled to be registered as proprietor under the 1925 Act, or entitled to apply to be registered under Schedule 6 of the 2002 Act now. In paragraph 40, my learned friend showed the court paragraph 40 and the three examples given by Lord Brown Wilkinson at the top of page 436 to illustrate the way that intention works. If I may pick up a question asked by my Lord Justice Zacaroli, it is established that there must be both a subjective intention to possess and an objective manifestation of that intention. Both are required. That was stated by the Court of Appeal in a case called Prudential and Waterloo. So if the squatter appears to be in possession, but in fact their real intention is to look after the property for the owner, so not for their own benefit, and that can be established, then they will not be in possession for the purposes of the Limitation Act.
And what is necessary for an objective manifestation?
What is necessary objectively is that they have manifested by their actions in relation to the land what their intention is. So in Lord Brown Wilkinson's example, the first example is a squatter, the second one is an overnight trespasser. Somebody who is in the house only overnight and then disappears is not manifesting by their actions any intention to exercise custody and control of the property for their own benefit. They're manifesting an intention to make very limited and short-term use of it and then disappear. But if that person then changed their mind and stayed there, then they would acquire possession. And as for the person who, the third example, which is the person who is a friend looking after the house of the paper owner during his absence on holiday, their intention is not to exercise control of the property for their own benefit. Their intention is to exercise benefit for the purposes of their friend. So even though outwardly they look like they are the owner of the house, they're behaving as an owner would. If it can be proved that their real intention was simply to look after it for the owner, then they will not be in possession as against the owner. They won't have dispossessed the owner. Paragraph 42, my learned friend correctly said there need not be any intention to own, and therefore if a squatter does not do things that an owner would, but which are unconnected with possession of the land, that's to say exercising control over the land itself, those acts will not render his actions equivocal. And then can I also ask the court to look please at page 446. The speech of Lord Hope, paragraph 71, he explains as well what the nature of the intention is. Just below letter B, he says it's reasonably clear that the animus which is required is the intent to exercise exclusive control over the thing for oneself. The important point for present purposes is that it is not necessary to show that there was a deliberate intention to exclude the paper owner or the registered proprietor. The word adverse in the context of section 15 of the Limitation Act 1980 does not carry this implication. The only intention which has to be demonstrated is an intention to occupy and use the land as one's own. And then on page 447, the next page in the speech of Lord Hutton, paragraph 76. Paragraph 75, he says the Grahams made full use of the disputed land as if they were the owners. They did everything which an owner of a land would have done. And when an experienced chartered surveyor called on behalf of the plaintiffs was asked in cross-examination what an occupying owner of the disputed land might have done over and above what was done by the Grahams between 1984 and 1997, he was unable to think of anything. And it was the use of the disputed land that he's referring to. And in paragraph 76, he says, I consider that such use of land by a person who is occupying it will normally make it clear that he has the requisite intention to possess, and such conduct should be viewed by a court as establishing that intention, unless the claimant with the paper title can adduce other evidence which points to a contrary conclusion. And then he says that when a person claiming title has occupied the land and made full use of it in the way in which an owner would, I consider that in a normal case he will not have to adduce additional evidence to establish that he had the intention to possess. It is in cases where the acts in relation to the land of a person claiming title by adverse possession are equivocal and are open to more than one interpretation, but those acts will be insufficient to establish the intention to possess. So the ambiguity has to relate to the acts in relation to the land.
So going back to your point a moment ago, do you say there are three requirements then? Possession in fact, intention to possess, and a manifestation of that intention? Or is really manifestation just part of establishing the intention?
It is said that, I mean, if the actions manifest the intention, then normally you can stop there, unless there is other evidence showing that despite what appears to be an intention to possess, in fact there was some other intention. There's an example in a case we will look at shortly, where somebody looked as though they owned the house. They granted tenancies of the rooms in the house in their own name. Everybody thought they were the owner, but in fact their intention was to look after the house for the estate of a deceased chief in Nigeria. And that was the evidence. And on that basis, they didn't have the intention to possess. But if you don't look as though you're possessing, then you don't have to go any further. If you look as though you're possessing, then it is relevant to see if there's any evidence that subjectively you didn't intend to do what you appear to be doing. As my learned friend said, with the person who's looking after his friend's house, it won't be apparent from his actions that he doesn't have the intention to possess. But if you ask them, they'll say, yeah, no, it's not my house, I'm just looking after it for my friend. At that point, you know they don't have the intention to possess. My learned friend showed the court the Say To Chung case, and I'd like to go back to that. That's at tab 12. It is a useful illustration of a point I wish to make, which is that it is not the case that a tenancy does always grant the right of exclusive possession. And my learned friend's right about that. A license sometimes does also grant a right of exclusive possession, and sometimes it doesn't. So my learned friend's wrong about that. This is an example of a license that did give a right of possession. At the bottom of page 1, 2, 3, 4, just below letter H, where the red sidelining begins, the facts of the case are summarised. May I ask the court just to read the red sidelined text, please? Page 194 of the bundle, 1, 2, 3, 4 of the law report. So this was a case, there is absolutely no doubt that the defendant was in possession of the land using the ordinary meaning of that word. They were in exclusive factual control, they erected buildings on it, they enclosed the land with a brick wall. It's a pretty unambiguous case of actions indicating that they were in control. And the permit they were given from the Crown entitled them to exercise that control of the land for a temporary period. And from time to time that permit was renewed. It wasn't a tenancy because it wasn't for a term certain. It was a license, but it was a license that gave the defendant the right to exclusive possession of the land. And my learned friend correctly says that the effect of the actual license that was granted by the Crown was that the defendant's possession was for and on behalf of the Crown, so that for Limitation Act purposes it was the Crown and not the defendants that were treated as dispossessing the paper title owner. If we could next look at tab 21, please. And Opanubian Daily. A decision of Mr. Justice Patton in 2002. And this case shows that exactly the same principle that we see in the Privy Council case applies in the case of a tenancy. Chief Adeboye owned a house and he employed Mr. Andresia to manage it for him. Mr. Andresia granted tenancy of the rooms in the house to various different individuals and collected the rent, acting as if he was the owner. And one sees that in paragraph 7 in the third sentence on page 403 of the bundle, paragraph 7 of the judgment. The recorder made a number of findings not challenged, and then the third sentence, he also accepted that the tenants dealt with Mr. Andresia on the assumption that he was the owner of the house and that misapprehension was not corrected by him. And in paragraph 13, in the third sentence, 2 lines up from the bottom of the page, he said, he managed the property, was in sole control of any lettings and received the rents. The fact that a particular room within the property was vacant at any one time was, he accepted, irrelevant. I agree with this. So Mr. Andresia looked as though he owned the house. He was collecting the rent. He was letting the rooms, naming himself as the landlord. Then the chief died. Mr. Andresia carried on exactly the same way. And he paid the rent to the chief's widow because he believed that she was entitled to the rents. Until in 1993, he stopped doing that because he didn't want to be involved in dealing with repairs. And after that, no rent at all was paid. And eventually, letters of administration were granted to an administrator of the chief's estate and possession proceedings were board. And the tenant said, well, Mr. Andresia was in possession of the property without anybody's consent because the person who'd given him consent had died and that terminated the consent. And we can add his period of possession to ours. And the answer given by Mr. Justice Patton was that Mr. Andresia was the one who was in possession, not the tenants. Reasons we'll come on to. And Mr. Andresia himself didn't have the intention to possess because he was intending to look after the house for the estate and giving the money to the person he thought was entitled to the estate. If we can look at paragraph 40. Paragraph 40? No, paragraph 14. If I could ask the court please to read paragraph 14. And then 15, he says, the statutory provision is reinforced by the general principle that a tenant's possession of land is treated for limitation purposes as that of the landlord. Although Mr. Andresia was no longer the owner's agent after 1987, he did in fact grant leases to the defendants, and they are his tenants. They are stopped from denying his title, and their possession from 1987 to 1993 was on his behalf. And then he cites the Se To Chun Kyong case, the Privy Council, to support that proposition. So for Limitation Act purposes, there is no difference between a tenancy and a license. In both cases, if there is actual consent to the occupation of the land, then the person in occupation is not treated as being in possession for Limitation Act purposes, even though they are in possession for the ordinary, given the ordinary meaning of that word. And then paragraph 16, Mr. Justice Patton explains why Mr. Andresia himself, his own possession was not capable of constituting adverse possession as against the estate. So he didn't have the intention to possess. The next subject I want to address is what's meant by ambiguity or acts open to more than one interpretation, which is what Mr. Justice Slade said in Powell and McFarlane, which my learned friend correctly referred to, And we go back to tab 6 to look at that, please. And page 472 of the law report, page 86 of the bundle. And this is where he says, and my learned friend read this passage to the court, that when considering whether a trespasser has acquired possession, the court will require clear and affirmative action. For the trespasser claiming he's acquired possession not only had the requisite intention to possess, but made such intention clear to the world. If his acts are open to more than one interpretation, and he's not made it perfectly plain to the world at large by his actions or words that he's intended to exclude the owner as best he can, the court will treat him as not having had the requisite animus possidendi. And we know from Pye and Graham that the phrase intended to exclude the owner is not quite right. What's meant is the intention to exercise exclusive control for one's own benefit. You don't have to actually intend to exclude the owner. You may think you're the owner. But what you do have to do is acts. So what sort of acts does Mr. Justice Slade have in mind? We can see that if we look at page 477. The last two lines of the page, there are a few acts which by their very nature are so drastic as to point unquestionably in the absence of evidence to the contrary to an intention on the part of the doer to appropriate the land concerned. The ploughing up and cultivation of agricultural land is one such act. Compare Seddon and Smith. The enclosure of land by a newly constructed fence is another. As Chief Justice Coburn said in Seddon and Smith, enclosure is the strongest possible evidence of adverse possession, though he went on to add that it was not indispensable. Placing of a notice, warning intruders to keep out, coupled with actual enforcement of such notice, is another such act. So too is the locking or blocking of the only means of access. Just pausing there, what Zacar did in this case was move into the flat, refuse to allow Iftikhar in and change the locks. So that is a drastic act which pointed unquestionably to him having the intention to possess. And then the contrast is drawn with the things that Powell had done in that case in 1956 or 1957. The acts done by him were of a far less drastic and irremediable nature. What he did in effect was take various profits from the land in the form of shooting and pasturage, hay and grass for the benefit of the family, cow or cows and goat, and to effect rough repairs to the fencing, merely to the extent necessary to secure his profits by making the land stock-proof. On many days of the year, neither he nor the animals would have set foot on it. These activities, done as they were by a 14-year-old boy who himself owned no land in the neighbourhood, were, in my judgment, equivocal within the meaning of the authorities, in the sense that they were not necessarily referable to an intention on the part of the plaintiff to dispossess Mr. Macfarlane and to occupy the land wholly as his own property. So that's what he means by ambiguous acts. It means when you do things on the land that could be because you're trying to exercise control over it, or could be because you just want to make some limited use of it. In this case, Zacar's acts were wholly unambiguous. In the supplemental bundle, please, at tab 13, this is a letter from Stevenson Harwood to Zacar, Malik and occupiers, dated the 16th of June 2017. And they say, as you are aware, we act for Iftikhar Malik, the legal and beneficial owner of the property. You illegally occupy the property without our client's permission and have denied him access to or the ability to in any way deal with the property since 1987. And then the end of the letter, on the next page, they say, in the meantime, our client's rights remain fully reserved, including in relation to recovering possession of the property from you. So to say that Zacar was not in possession of the flat using the ordinary meaning of that word is in our submission quite untenable. There could not be a more complete case of dispossession than this one. If Zacar had gone away on holiday and found a squatter in the flat, he could have brought trespass proceedings against the squatter. And if the squatter had tried to defend those proceedings by saying, I've just discovered that you asked your brother, who's the registered proprietor, to pay the service charges, judgment would have been entered instantly. A squatter who breaks into a flat and changes the lock, intending to stay as long as they can, has possession of the flat, whether they, even though they don't pay the ground rent, or the utility bills, or the council tax. They want to stay as long as they can. They know that non-payment of those things in due course will lead to them being evicted, but they have the intention to possess. So my learned friend says Pavlidis supports his submission. It doesn't. You can go back to that in Authorities 1, tab 8. So the problem with this site can be seen from page 464 of the law report, page 147 of the bundle. The second full paragraph on the page beginning, there is also in the GLC files. Does the court see that?
No.
Page 1.
Oh, yes, yes.
Page 147, about a quarter of the way down. There's also in the GLC files a record of a telephone conversation on March the 12th, 1971. It reads as follows, so far as relevant: Arcola Street, then a telephone number, broken into from GLC property, which is going to be used as a car park. Spoke to company secretary. The site is in Millers Avenue, Arcola Street. The fencing has been down for the past 5 weeks when the company suffered another break-in. And then there's more to the same effect. So that's the context for what one sees on the next page, which my learned friend showed the court, where Mr. Justice Knox said that occasionally the corrugated iron fence came down, helped on its way by school children from the school to the northeast of a disputed site, who could and did get onto the disputed land and vandalise whatever came to hand, and also by casual fly tippers. And then it says, the people who complained from time to time to the GLC included Mr. Pavlidis himself, as he volunteered in his evidence in chief. It doesn't say Mr. Pavlidis contacted the GLC and said, I am in control of this site and I'm willing to let you come in to fix the fence. He was just one of the people who was complaining, as owning property adjoining this site, about the thieves and vandals and fly tippers who were causing a nuisance. And the nuisance was sufficiently severe that if one looks at page 468, first break of paragraph at the top of page 468, in January 1983, the Hackney Borough Council issued a summons on the GLC, charging that pursuant to a statute prohibiting the recurrence of a statutory nuisance under the Public Health Act 1936, namely an accumulation of miscellaneous bagged and loose refuse dumped on vacant land, and requiring you to take certain steps as where necessary to prevent a recurrence of a nuisance duly served on you as being the owner of the said premises. So there were problems with this site, with people coming onto it when the fence came down. And that's the context for the passage that my learned friend relies on at the end of the judgment on page 480 to 481. When he says at the top of page 481, Mr. Pavlidis cannot validly claim himself to be in adverse possession as against persons whom he actively requested to shoulder the responsibilities that possession has. That related to acts on the land itself. And as Mrs. Justice Bacon correctly said in paragraph 99 of her judgment, it reflects the principle that in order to be in possession, you have to manifest the intention to control the property by your acts, and a request to the owner to do things on the land itself, repairing the fence to keep trespassers out, isn't a manifestation of an intention to exercise control over the land. If Mr. Pavlidis had written to the GLC saying, "This is my car park, I'm in control of it, I want you to come and fix the fence," it might have been different, but that's not what he did. He was just one of a number of people who were complaining in their capacity as owners or lessees of adjoining property about the state of the site. And in my skeleton argument, I said possession doesn't have responsibilities, but does have attributes or characteristics, which is all that Mr. Justice Knox meant. But reflecting on it, it occurred to me that possession does have responsibilities. The person in possession can be held liable for causing a nuisance or allowing a nuisance to be caused on their land. And that is something that attaches to possession, not to title. Somebody is in control of land, then they owe a measured duty of care to their neighbours to prevent things on the land from getting into such a state that they may cause damage or annoyance to their neighbours. So it may well be that that's what Mr. Justice Knox had in mind, that this was all about nuisance coming from this site. And when there were actual or potential nuisances, the person who dealt with those nuisances on the land itself would be the person who was exercising control and manifesting the intention to exercise control. So this case gives no support whatsoever to His Honour Judge Gerald's decision that asking somebody to pay service charges, which has nothing to do with acts on the land itself, meant that Bacar did not manifest the intention to possess. As to the Northern Irish and Hong Kong cases relied on by Iftikhar, they were, as Mrs. Justice Bacon said, concerned with different issues and give no support to Iftikhar's argument. My learned friend didn't go to those, nor will I.
Mr. Jordan, you would say then that payment of a service charge is an incident of the paper title and has no ramifications in relation to possession. Is that?
Yes, my lady, precisely. Exactly as Mrs. Justice Bacon said, it's an incident of being the tenant under the lease. The obligation to comply with the tenant's covenants falls in the first instance on the original tenant who enters into a contract and then binds subsequent tenants by privity of estate.
Absolutely. And what do you say then about Mr. Momby's analogy that he sought to draw between paying the service charge so that the lease doesn't come down on your head in comparison with mending the roof?
Mending the roof, the roof is part of the property. That's an act done on the property, like fixing the corrugated iron fence in the Pavlidis case, or fixing the concrete canopy in the Hong Kong case, cutting the tree back in the Northern Irish case. Those are all concerned with the property itself and exercising control over the property itself. Paying money to somebody so as to avoid, perhaps in the far distant future, being evicted is a completely different sort of action, and not one that tells you anything about whether the person who is in control is intending to exercise that control for their own benefit. It would be the same if there was a mortgage on the property. The fact that the squatter doesn't pay the mortgage and asks the owner to pay the mortgage doesn't mean that the squatter isn't excluding the owner and exercising exclusive control for their own benefit. In due course, no doubt the mortgagee will take possession proceedings and they will have to go. Same with the landlord. If ultimately the service charges aren't paid, the landlord will first have to get an agreement or determination that the service charges are due, and then they can serve a Section 146 notice. And then if that isn't complied with, then they can start forfeiture proceedings in the county court, and then the court will make an order giving 4 weeks for the money to be paid. And if it isn't paid, then the bailiffs will be instructed, and based on current experience, several months later, the bailiffs will actually turn up and evict the person in possession. But the fact they don't pay the service charges may lead, probably will lead, to that chain of events. Doesn't mean they don't have and manifest the intention to exclusively control the property for their own benefit. May I just quickly deal with some cases that show that a person can be in possession even if somebody else is paying the financial obligations under a tenancy of that property. My learned friends referred to a case called Pekin and Pekin. before looking at that, it's necessary to just put it in context. In the second volume of the authorities bundle, tab 56, rather than make the court read the rather outdated language of section 7 of the 1833 Act, if the court turns over to page 1387 of the bundle, tab 57, no, that's the wrong one, it's tab 58. This is section 9 of the Limitation Act 1939, subsection 1, a tenancy at will shall, for the purposes of this act, be deemed to be determined at the expiration of a period of 1 year from the commencement thereof, unless it has previously been determined. And accordingly, the right of action of the person entitled to the land, subject to the tenancy, shall be deemed to have accrued on the date of such determination. And there was a similar provision, although not worded in quite that way in the 1833 Act. So at all times up to 1980, the law was that if somebody was in possession as a tenant at will, then if they didn't pay any rents, then from the anniversary of the grant of the tenancy at will, time would run against the owner, and after 12 years, their title would be barred. That wasn't the case where there was a license, but it was the case where there was a tenancy at will. So there were cases where the court had to decide if there was a license or a tenancy at will. And one of those is Pekin and Pekin, which is in Authorities Volume 1, Tab 3. The head note says the owner of a house allowed his sisters to reside therein and contributed to their support. He paid the rent and taxes and executed all necessary repairs, held that the occupation was in the character of guests and not of tenants at will, and the statute of limitations did not run as against the owner. So all this was a finding that on the facts there was no tenancy at will, but simply an informal family arrangement on which the owner of his house, out of kindness, allowed his sisters to reside in the house. There is, in fact, no mention anywhere in the report that the judge paid any attention to the fact that the plaintiff was paying the rent. What he says on page 361 of the law report, 4 lines up from the bottom, their brother, the owner, assisted them to support them, partly by giving them a gratuitous accommodation in the house, partly by contributing supplies, and the occupier's taxes were throughout paid by him. That's what he says. And then he goes on to explain why the proper inference is that they were just his guests. There was no contract of any kind, let alone a tenancy.
Was it a total defence to an adverse possession claim in those days that if you were there with the consent of the owner, there could be no adverse possession? That would be an answer.
Well, if they were tenants at will, my lord, then time would have run under Section 7 of the 1833 Act from the first anniversary of a tenancy at will.
That's an exception to the you're there
Yes.
with consent. So it wasn't an absolute defence of I'm here, you're here with my consent.
It was an absolute defence if you were there with consent and there wasn't a tenancy at will. But if there was a tenancy at will, then time ran against the owner and that was until the Limitation Amendment Act abolished that.
And that's what this case is. It's being said that the sisters were there with consent.
With consent and without a tenancy at will.
Yeah.
The next case is at tab 4. And it's called Lines Against Snaith. And if we look at page 486, the first page of the law report, Mr. Snaith owned 11 cottages, and he gave permission to his defendant, his daughter-in-law, to live in one of them. And she entered into possession and continued in possession. In 1987, Mr. Snave died and left the cottage in question to the plaintiff for life. In 1897, the trustees asked for payment of rent, which she refused on the ground that she'd acquired a statutory title. And then it says it appeared that John Smythe had from time to time during the period that the defendant was in occupation sent workmen onto the premises to repair the cottage in the same way that he repaired his other cottages, which were let to tenants at a rent. And at the bottom of the page, it says John Snave, down to the date of his death, paid the water rate, insurance and property tax in respect of number 27, in the same way that he did in respect of his other 10 cottages. And then the county court judge held, one sees this on page 487, the first red sidelining, the county court judge held that the defendant was a licensee, not a tenant, relying on Pekin and Pekin. And then Mr. Lush, for the defendant, said it was admitted that the defendant was in exclusive possession, therefore she was not a mere licensee. And that was accepted on page 488 in the judgment of Mr. Justice Lawrence. And if I could just ask the court to read the red sidelined passage in the judgment of Mr. Justice Lawrence. So that was the test. If there was no contract at all, as in the Pekin case, just a gratuitous arrangement with a family, then obviously there was no tenancy at will. But if there was something more than that, then if there was exclusive possession, then there was a tenancy at will. And then the last case on this point is tab 5, which is a case called Taylor and Twinborough. This was a case very like the one we've just looked at, except in this case, a person who allowed a relative to live in the property rent-free had a tenancy of it. One sees that in the facts. Mrs. Emma Ferguson granted to Mr. Alfred Henry Taylor a tenancy from year to year of a piece of freehold land and a cottage and other buildings at an annual rent of £25. At the commencement of the tenancy, Mr. Taylor placed his brother-in-law, Mr. Twinborough, who was then his foreman, in occupation of the cottage rent-free, and on the latter's employment as foreman ceasing shortly afterwards, allowed him to remain in occupation of the cottage rent-free, Mr. Taylor himself continuing to discharge all the obligations under his tenancy by paying rent, rates and taxes, and by keeping the property in repair. So this was a situation where somebody was in occupation, not paying any rent, and the person who let him into occupation was paying the rent under the tenancy and all the other obligations imposed by the tenancy. And there were two issues in the case. One was whether there was a tenancy at will, in which case time would run from the first anniversary of the date when the brother-in-law went into occupation. And the other was whether things were affected by the fact that Mr. Taylor later bought the freehold. And in the divisional court on appeal, one of the two judges dealt only with the second point, the freehold purchase point. Lord Justice Scrutton dealt only with that, but Lord Justice Lawrence dealt with the other issue as well on page 24 of the law report. The last 3 lines, Lord Justice Lawrence said, the first question which arises, in what character did the defendant and her late husband occupy the cottage? It is contended on behalf of the plaintiff that the true inference to be drawn from the facts is that A.H. Taylor remained throughout in possession of the cottage and merely allowed the defendant and her husband to live in it as his guests. In support of his contention, counsel relied upon the Irish case of Pekin and Pekin. My judgment, that case is distinguishable on the facts from the present case, which in turn is indistinguishable from and governed by the decision of the divisional court in England in Lyons and Snake. So it didn't make any difference in this case that the land was held under a tenancy and that the person who allowed that the brother-in-law in was paying the rent under the tenancy. That did not affect the fact that the brother-in-law was in possession of the property. That is completely inconsistent with my learned friend's submissions. So for all those reasons, Mrs. Justice Bacon was right on this point, the service charge point, and and His Honour Judge Gerald fell into error in treating the obligation to pay service charges as an incident of possession. It's nothing of the sort. The final topic is the question of whether the things Zacar said about his basis for occupation of the property meant he didn't have the intention to possess, or didn't manifest the intention to possess. The court has seen in the Ofulu case that where somebody claims that they are the tenant, even though they're not, they do manifest the intention to possess. But my learned friend says licenses are different. And if we can look first of all at the Lambeth and Rumbelow case, which is Authorities Volume 1, Tab 16. Mr. Rumbelow was one of a number of squatters in a property which had been the subject of a license granted by the council, but they had terminated the license and started possession proceedings. And then Mr. Rumbelow had solicitor's right to the council, and one sees on page 6 of the transcript the letter that was sent. Perhaps I'll just read the last paragraph of that letter. In the circumstance, we would submit there's a license to occupy the property granted by London Borough of Lambeth, or in the very least a triable issue in respect of this matter. We therefore ask that possession proceedings be suspended and Mr. Rumbelow be given the opportunity to prepare a defence. And that had the effect that the registrar directed that the proceedings continue on the basis of an arguable defence. Directions leading to trial were given. And the council then discontinued the proceedings faced with that defence. And there were a number of points made by Mr. Justice Efferton. The first point he decided the case on against Mr. Rumbelow was that on those facts there was a licence. Mr. Rumbelow had caused his solicitors to say he had a licence. The council had withdrawn the proceedings, obviously accepting that assertion, and from that it could be inferred that the council was permitting the occupation of the property by Mr. Rumbelow and his fellow occupiers. That was enough to dispose of the case, so the case was rightly decided. It's what he went on to say as an alternative ground for his decision that we take issue with. And that begins on page 263. He says at line 22, the letter contains a clear assertion that there was a licence, which of course it did. And then on page 266, line 10, that Mr. Rumbelow must have believed, following advice to him by his solicitors in May 1986, and bearing in mind the contents of the letter, that there was a licence. And he must have believed that the council accepted that assertion in view of the council's discontinuance of the possession proceedings following the receipt of that letter. And then he deals with there being an actual licence. And then when it comes to the question of the intention to possess, his reasoning is set out on page 275 at line 20. Sorry, page 28 of the transcript. 275 of the bundle, page 28 of the transcript. He's just been referring to a case that had been cited by Mr. Naffler about a tenancy, where the tenancy was deemed to come to an end, and the Court of Appeal said that there was possession and the intention to possess. And at line 19, he says, I do not see how that case helps Mr. Rumbelow here. I find that he believed there was a licence by virtue of which he could remain in the property. He presumably therefore intended to assert such rights as that licence could legally convey. Unlike a tenancy, a licence, above all a bare licence, is a purely personal right and does not confer exclusive legal possession, nor so far as concerns a licensee is there any similar statutory provision to Schedule 1, Paragraph 5 of the Limitation Act. And in my submission, that's just wrong. There can be a licence that confers exclusive possession. There was one in the Hong Kong case. There is one virtually every time a business being conducted in leasehold premises is sold. What nearly always happens is that the business is sold and the vendor says, I will apply to the landlord for licence to assign the leases. In the meantime, you can occupy and run the business as licensee. indemnifying me against the rent. And when we get the landlord's consent, I will assign the leases to you. That doesn't create a tenancy or a subtenancy because it's not for a term certain. It does give the person who's bought the business possession of the business premises. They're running the business, they have the keys, they're in control. It's a very common situation. There are other situations where there are licenses which confer possession, but which are not for a term certain. There was one considered by Mr. Justice Edwin Johnson recently in the upper tribunal, a license for occupation of a telecommunications site, which he said didn't create a lease, although it gave exclusive possession because it wasn't for a term certain. So Mr. Justice Everton is simply proceeding on a false hypothesis in saying that a license cannot confer exclusive legal possession. Some licenses don't, many licenses don't. Many licenses only confer the right to the use of premises in common with the grantor or in common with others, but some licenses do. Anything which looks like a tenancy, but which does not in fact create a term certain, will create a contractual right to possession, but it won't create an estate in land. So with great respect to Mr. Justice Etherton, who generally got things right, on this occasion he didn't. His reason was unsound. Clowes and Walters is the next case at tab 25. This was a case where a widow had been given a license to occupy premises. Well, I can see that on page 4 of a law report of paragraph 6. I and Felice Walters hereby acknowledge that I hold my farm and land as licensee of Mayfair Property Development Co. Limited, rent-free as licensee only, and I agree to give vacant possession of the whole or any part thereof at any time. Well, that was a license that gave her possession. It wasn't a tenancy because it wasn't for a term certain. She then moved out, leaving her daughter Claire and her daughter's boyfriend Nigel, who later became Claire's husband, in occupation. And when possession was claimed, they said, well, you gave a license to Anne Walters, you didn't give a license to us. And that didn't succeed. And one can see a number of reasons why it wouldn't succeed, but the one that was used by Mr. Justice Hart to reach that conclusion is, one can see on page 13 of the report, paragraph 39 and 40. Can I invite the court to read paragraphs 39 and 40, please?
Certainly.
So the key part of his reasoning is at the bottom of page 13, where he says, in the example, A's response to inquiry as to how he happens to be in occupation and control of a locked house is that he is there with the permission of a true owner. It is not open to him to say that by being there, he intends to dispossess the true owner. And the language betrays the error in the reasoning. There is no requirement of an intention to dispossess. It's a resurrection of the way of looking at adverse possession that Lord Brown Wilkinson made clear was incorrect. You don't need to intend to dispossess the owner, you only need to intend to exercise exclusive control over the property for your own benefit. And they, Claire and Nigel, did intend to do that. And the fact that they thought that they had permission to do it doesn't mean that they didn't have the intention to possess. If they had had the consent of a true owner, then their possession would not have been possession or dispossession for the purposes of a Limitation Act, but would have been on behalf of the grantor of the permission. But that wasn't the case.
Mr. Justice Hart contrasts the position with them having been tenants, or believing they were tenants, even though they weren't tenants.
He didn't discuss that comparison, no. So his reasoning was quite different to that of Mr. Justice Efferton. Mr. Justice Efferton said, well, a licence doesn't give possession, so if you think you're a licensee, you can't be in possession. And Mr. Justice Hart says, if your state of mind is that you're there with the permission of a true owner, then you can't say that you intend to dispossess the true owner. But then my answer to that is, well, you don't have to intend that. It's not the necessary intention. The next one is tab 26, which is Reetham and Ross. This was concerned with property which was being used by Captain Warwick with the permission of his neighbour, Mr. Bedwood. And then Mr. Bedwood died, and Captain Warwick carried on using the property as before, thinking he had permission to do so when he didn't. One sees that from paragraph 40, page 573 of the bundle. Mr. Justice David Richards said the position was that he believed that he was using the stable with the owner's permission, but in fact from Mr. Bedwood's death in 1968, he did not have the owner's permission. Then at paragraph 41, he said this is an insufficient basis on which to conclude he did not have the requisite intention to possess. The relevance of actual consent of the owner is that it prevents the occupier from being in adverse possession for the purposes of Schedule 1, paragraph 8. It does not mean that the occupier is not in possession. Likewise, an erroneous belief by the occupier that he has the consent of the owner does not mean that he's not in possession of the property. On the contrary, the missing element of the owner's consent will mean that he is in adverse possession, except that it would perhaps have been better to say possession in the ordinary sense of the word rather than adverse possession, given what Lord Brown Wilkinson said. That is entirely correct. And at paragraph 43, he says, as Lord Hope observed in the passage cited earlier in this judgment, it's not necessary to demonstrate a deliberate intention to exclude the owner. That's contrary to what Mr. Justice Hart thought. It can fairly be inferred from Captain Warwick's erroneous belief that he was using the stable with the owner's permission that he would have given up occupation if requested to do so, but that does not prevent the existence of an intention to possess. See Lord Hutton at paragraph 78. And then his conclusion in paragraph 44 was that his possession of the stable demonstrated an intention on his part to possess it to the exclusion of all other persons, including the owner, unless and until asked to give up possession. His possession was adverse because he did not have the owner's consent. It follows that his erroneous belief that the agreement with Mr. Bedwood continued did not prevent him, or through him the appellant, acquiring a possessory title to parcel 2. And then the last case on this topic is tab 28. Decision of Her Honour Judge Marshall QC, sitting as a Deputy Judge of the Chancery Division. And here there was a licence, which one sees at paragraph 80, paragraph 14 of the judgment. Mr. Alston was a farmer. There was some land owned by Barkers, and Barkers gave him permission to farm it, and he wrote an acknowledgement saying, I acknowledge that I'm a mere licensee paying no rent of the land, and that I must give up possession of all or any part of the land to Barkers and Lee Smith Norfolk Limited without notice whenever required so to do by them. This is another license giving possession. Mr. Alston, by his company, J. Alston and Sons Limited, took possession, farmed the land for many years, And then in 1977, Barker's conveyed the land to an associated company called Pools and White's Food. And what they didn't realise was that that had the effect of terminating the licence, because it wasn't a tenancy. Although it gave a right to possession, it wasn't for a term certain, therefore it didn't create an estate in land, and it didn't bind a successor in title. And paragraph 20, both parties to this action are agreed that this transaction had the effect in law of terminating the licence agreement made in 1974. In practice, nothing changed. Mr. Alston continued to cultivate the orange land together with the rest of the field as already described. So that's what gave rise to the issue. And then if we can turn on to paragraph 86. I find that Mr. Alston's state of mind is really quite clear. He knew that he had a licence from the previous owners. He did not know exactly what had happened. He knew that there were new owners, or at least new people in charge. He did not know what their attitude would be or if the arrangement still stood. However, he wanted to go on farming the land and to do so as long as he possibly could. He didn't want to risk upsetting the apple cart by making inquiries, because then he might be asked for possession or for rent. He was therefore happy enough just to keep his head down and to continue farming the orange land together with the rest of the field for as long as he could, until someone with the right to do so stopped him. And paragraph 82, further up, the judge records that Mr. Alston agreed that if Pauls had told him that he had to go, he would have accepted this and gone, although he added, but they didn't. He agreed that he had assumed that he was entitled to farm there only as long as Pauls did not require the land. So that was his state of mind. And then the judge reviewed some authorities, including Clowes and Walters and Reetham and Ross, but not the Rumbelow case. And at paragraphs 89 through to 91, the submissions that I made on behalf of Alston are recorded. And then at paragraph 96, it's recorded that Mr. McGee, who was appearing for Pauls, was relying on Clowes and Walters. And at the bottom of that page, paragraph 97, it's recorded that I submitted that insofar as the case is contrary to the position which I contended for, it was wrongly decided and inconsistent with Reetham, which was to be preferred. Mr. McGee said that Clowes was a better case. And at 98, she says, I prefer Mr. Jordan's arguments to those of Mr. McGee. I find that Mr. Alston's state of mind was one of sufficient animus possidendi to make Alston's possession, adverse possession properly so called. I reject the argument there has to be an intention to infringe the rights of a true owner, which is what Mr. McGee was saying, which seems to me to be reintroducing the deprecated connotations of conflict attaching to the label adverse possession. Paragraph 100, she says, insofar as there's a conflict between Reetham and Clowes, I unhesitatingly prefer the former, and the expressions of principle of Mr. Justice David Richards as being more in accordance with the judgments in Pye than with respect to the latter. In finding that the two occupants never intended to dispossess the true owner, Mr. Justice Hart was again reintroducing extraneous notions of confrontation that are inappropriate, and was converting the requirement of an intention to possess into one of an intention to dispossess, which is incorrect and unnecessary. In my submission, she was right about that. And then in the next paragraph, she says the decision was unsurprising and could have been justified in other ways, either by saying that the contact between the owners and the occupiers was sufficient to give rise to the inference of permission, or by saying that when there was an intercompany transfer of the land, it was subject to an implied obligation on the transferee to respect the occupation, and therefore there was a constructive trust, either of which would have been sufficient to enable Mr. Justice Hart to arrive at the decision he did arrive at. And she says at the end of paragraph 101, Mr. Justice Hart could necessarily have reached a similar conclusion, whether as a result of an implied license or more probably some form of estoppel or constructive trust, which I respectively think would have been more satisfactory for the law of adverse possession. And we submit that Our Honour Judge Marshall and Mr. Justice David Richards were right, and with respect, Mr. Justice Hart and Mr. Justice Everton were wrong on this point, and this court should so determine. An occupier who wrongly believes or asserts that they have the permission of the owner, but who is exercising exclusive control of the property for their own benefit, does have the intention to possess. If they actually had a tenancy at will, then their possession would be on behalf of the owner. But a tenancy at will is a tenancy that can be determined at any moment by the landlord. All the landlord has to say to the tenant is, I don't want you here anymore, and then the tenant has to go. So it's a very fragile form of permitted possession. It's not a long-term, they can go on for a long time, but they are inherently capable of coming to an end briefly and abruptly. And there's no doubt that if somebody had a tenancy at will, they would have the intention to possess. And in my submission, it's equally clear that if they thought they had a tenancy at will, or said they had a tenancy at will, but they didn't, they would still have the intention to possess. As to Zacar's actual intention, he consistently asserted that he had the right to the permanent possession of the flat. The court has seen his statement of claim in the 1987 partnership action. That's what he said then. His affidavit said the same. I won't take the court to it given the time, but the court wants to see what he said in the affidavit he swore after Iftikhar began the possession action. That's in the supplemental bundle, tab 1. Relevant paragraphs are paragraphs 12, 22, 29, 33, and 95. He said he had the right to possession of the flat indefinitely. In his 2000 application to the land registry, which was after the end of a limitation period, he said that the flat had been purchased for him by agreement with his father and his brothers, and I treated it as my own, so that undoubtedly manifests the intention to possess. Well, he was asking the land registry to register him as proprietor. That was his position at the end of the limitation, after the end of the limitation period. And in 2011, 12 years after the expiry of the limitation period, his position was, as the court saw in his evidence yesterday, which we spent some time on, his evidence was that it had been agreed that the flat belonged to his father, and that his father had decided that when his father died, Zacar would own the flat, and in the meantime he would have a right to permanent occupation of the flat, which was referred to as paragraph 13 of his witness statement. He said, father has given in effect lifetime tenancy of rent-free occupation. So at no point was he saying, I think I have an arrangement which doesn't give me possession, nor was he saying, I think I have an arrangement that I can only stay here as long as somebody else lets me. He was saying, I have the right to indefinite possession, and that is sufficient for him to have had the intention to possess, even if Miss Justice Everton and Miss Justice Hart were right. My lady, my lords, unless there's anything else I can...
Thank you very much indeed. Mr. Malik.
Grateful. I'm conscious that past 7 minutes from now, I'm presuming on the court.
You'll cope.
I'm very grateful to that. I shall endeavour to presume on the court as little as possible, and you're right, but please, so far as I'm concerned, to tell me as soon as I start to overstep or whenever I should move more swiftly. What I do propose to deal with for a few minutes is the respondents' notice points, because I didn't deal with them earlier and I said I'd take them in reply. So I'll deal with them swiftly, and I will then maybe pick up one or two points where I may be doing more than just repeating myself this morning, although I'm conscious of this that I will be. The respondents' notice points are fourfold. The first is the point that Zacar's statements to Mr. Jarvis were immaterial, because Mr. Jarvis would have had to refuse the application in any event. There are two reasons why that's a bad point. The first is the reason given by Mrs. Justice Bacon when she refused to accept this point below, which is paragraphs 54 to 59 of her judgment.
Sorry, 54 to 59?
54 to 59 of her judgment, which I endorse. There is no warrant in the authorities for the idea the court is supposed to embark on a counterfactual analysis. Well, the first court would have decided, but for the relevant stance being adopted by the party. As the judge held in paragraph 56, Mr. Justice Bacon, it's not a but-for test. What one's looking for is, was it a reason? Is it part of the footing on which the decision was given? Sometimes it'll be apparent it was decisive, sometimes it won't. Where the assessment first time round is discretionary or multifactorial, it will very rarely be possible to say it was the decisive factor. One's looking for, was it a reason? That's one language used in LA Micro. Was it on the footing of? And here, as the judge held in those paragraphs, it's self-evident that it was. As anyone looking at paragraphs 119 and 130 of the Jarvis judgment can see that this was an important factor in his decision. And it's just not appropriate then to say, well, if you take that out and think about how the discretion would have been exercised if you took that one factor out, that's not what the principle requires you to do. There's no warrant in the authority for that. And indeed, my learned friend, as I understood what he was saying earlier, it says that the point he is making, at least as currently formulated, is that he accepts that it's not enough to say it might have been different. He now says that he has to put it as high as it would necessarily have been different. In my submission, that's still wrong in principle, because one shouldn't be unpicking the prior judgment in which one can see that this was on the judge's actual reasoning an important factor. That's to conduct a sort of de facto appeal now against the decision of Mr. Jarvis back in 2011, without this court knowing, of course, what was all the evidence, what were all the submissions, what were all the arguments. One just can't reopen the whole thing and say, well, if you take that factor out, you necessarily must have decided it one way. Not an appropriate exercise. And it's also wrong in fact, that's the second point. The whole point rests on the idea the 1987 claim could never have been revived, effectively resting on what Mr. Jarvis said in para 133, where he talked about it being a paradigm case where it would have been struck out under the old jurisdiction. But plainly he wasn't saying that the case actually would fall to be struck out on that basis, all things considered. And certainly not that that would be the right decision if the consequence would be that Iftikhar would face an adverse possession defence. The whole basis of his judgment was that it was proceeding on the basis that Iftikhar wouldn't. It's plain that he wasn't contemplating that it would be appropriate to strike the claim out in that way. And indeed, he was very clear in his consequential remarks that he wasn't doing that, and the whole premise of what he was doing was that the case would go on. In any event, it's also right to say that he didn't have reference specifically to the test in Burkitt or Arbus not Latham. He didn't set any of that out. It was something of a, with respect to him, a throwaway remark in the course of an extempore judgment. Had he gone through the test in those cases, he would have concluded that the case shouldn't be struck out, in my submission. The threshold requirements, under those principles, we have a threshold test, which is there has to either be intentional contumelious delay or inordinate and inexcusable delay, giving rise to a substantial risk of an impossibility of a fair trial, or likely to serious prejudice. And if that threshold is met, then it's a discretion. In our case, the first threshold criterion was clearly not met. There's no suggestion of a contumelious breach. The second one shouldn't be regarded as met either. While Mr. Jarvis made remarks about the difficulty of a trial, he clearly didn't think that there was a serious risk of a fair trial being impossible. His whole premise of his decision was that there would be one, and that was what was meant to happen. And in any event, if, on my learned friend's premise, one is unpicking now and looking back and saying what should have happened, well, we now know, as I submitted yesterday at length, the trial has taken place, and in my submission, no one can say it's unfair. So the idea that one can say, well, looking back, it was an absolute dead cert, it should have been struck out in 2011 because one could see at that stage there was a serious risk of fair trial was impossible, is a very unattractive submission when one now knows a fair trial has taken place many years later. If anything, we'd have been better off with the trial at that time because the assumption has to be the evidence would have helped us because we know that we're in the right. And indeed, more specifically, one point, it's a point of detail, Bilal, party's father, was still alive at that time, and we know that he was a witness who was broadly supportive of us. That's recorded in paragraph 27 of the general judgment. insofar as it's a matter of discretion, if the threshold had been crossed, again we say it's obvious that Mr. Jarvis would not have struck the claim out, given what he decided throughout the rest of his judgment. But as I say, one shouldn't get into this at all. One should nip it in the bud, because one shouldn't be in the exercise of trying to reopen that decision. It's enough to say, well, it was a material consideration on which the court was relying. It was a reason, it was the footing, whatever phrase you want to use. Point two, that's the first point, which is one of the two bigger points. Point two is a point taken about the pleading point, about dishonesty. There are a number of answers to this to give. I do submit that the pleading was an entirely sufficient one to make the point that it was making, that in light of the position that was put forward to the court at that time, it would be an abusive process to enable the adverse possession claim to defence to be run now. I say that was sufficiently pleaded. I say the question of whether dishonesty needs to be pleaded is ultimately whether dishonesty is an element of the cause of action or the legal test that is relied on. And here it was not a necessary element of that. It's not like claiming deceit. That's point one. Point two is the reality of this claim is that this point was not entirely squarely a point confined by the pleadings in the way that it might otherwise have been. There'd been a very fully argued set of strikeout proceedings that had gone up in front of Mrs. Justice Falk, where there'd been much discussion of what the issues were on abuse, and that it was a broad factual inquiry. That's paragraph 47 of the Falk judgment, page 159 of the supplemental bundle. In a case like that, in my submission, one has to be realistic then about saying the parties are confined to the pleadings, when everyone knows, having argued in extenso on an interim basis in the meantime, what the scope of the arguments for trial actually are. It is also the case that the issue around the strikeout was before the court, both on the pleading and also as an application. It was a live strikeout application, which His Honour Judge Gerald was dealing with. He was dealing with an application point and a point for trial at the same time. So again, it's not quite a case of pleadings being the be-all and end-all in the way that they would be in another case, even if it were right that more should have been said. That's the second point. Third point is the pleading is pleaded on the parties' positions as they're known to be. The point being taken was that was the position he took before the court, and that was. I'm rightly being told that I didn't intend to give the court the impression that it had been actively said to Mr. Justice Falk that there was a dishonesty allegation. If your Lordship understood that, then that was not what I intended to convey. I'm not sure that dishonesty, I don't know whether dishonesty was mentioned on. The point I'm making is not about dishonesty being mentioned, Mr. Justice Falk specifically. It's about it being understood at that stage as to the broad multifactorial basis of what the argument would be at trial.
Thank you.
The third point, which I was making before I unhelpfully backtracked, was that the pleading necessarily reflects the point that was being put forward at the stage of pleading the reply by Iftikhar, which is this is the position backup conveyed then, and that prevents him now from putting forward a different position. It wasn't known in full at the time of pleading it, of course, everything Vakar would say about it, and that his evidence would be about how, well, I didn't say that, and that's not what I meant, and I didn't understand what was going on, and all of the explanations that would be given. Necessarily that evidence was given and it was developed as the proceedings developed and ultimately as the trial developed, as cross-examination took place. And by the time you get to the judgment, that investigation has occurred, those explanations have been given, and the findings have been made about them, which they have. And of course, at that stage, the judge will take into account the full findings they have made. That's not to say they should have been pleaded, they couldn't have been pleaded at the start. wanted to know how it was going to unfold. That's the fourth point I was making. The fifth point is that it's accepted that there's no challenge to the findings insofar as they go to Vacar's understanding of the position as to what was being said in front of Mr. Jarvis. And in my submission, a distinction between findings as to Vacar's understanding and findings as to Vacar's motives and honesty, which is the distinction my learned friend now draws, is a thin and in reality artificial distinction. If you look at what Sonny Judge Gerald was finding, the findings he was making about Vacar's understanding are in effect the same in content or very close in content to the findings he was making about motives. They're inextricably linked up. And the fifth point is this. Part of the way in which my learned friend emphasises this is to put the fact of dishonesty at the heart of the assessment that His Honour Judge Gerald made in paragraph 100. In my submission, while I can't say that his findings as to Vacar's disingenuousness weren't part of the picture, they're not front and centre. What is front and centre are the findings that this was the message that Vacar intended to convey, i.e. that there would be no adverse possession defence. And this is the message which he did convey, i.e. that there was no adverse possession defence, and that is how the judge understood it. The fact that in doing that he was being disingenuous is part of the story that gets to there, part of the findings that get to there, and obviously it colours the way the judge assesses it. But the dishonesty is not in fact at the heart of His Honour Judge Gerald's assessment. It's the fact that Vacar set out to and succeeded in convincing the judge of that position. So that was the second point. Third and fourth points I'm not sure I need to develop in any detail. The respondent's notice points, I should say. The third respondent's notice point is that His Honour Judge Gerald failed to take into account the serious consequences of his decision in depriving Vacar of what would otherwise be a good defence. In my submission, Ms. Justice Bacon was right to dismiss that point as fanciful and not realistically arguable, as she did in paragraph 77. Of course, His Honour Judge Gerald appreciated that and took it into account in the balance. It was the whole point of the argument before him. It was the variable point of deciding. And the fourth point, taking the respondent's notice, is that His Honour Judge Gerald's decision was outside the ambit within which reasonable disagreement is possible, and everything previously said by my learned friend is prayed in aid. In my submission, that all the previous things added together are enough. Point is a make weight. It adds nothing to the points taken individually. And in any event, the points taken individually are bad ones for the reasons which I have given. Those are my submissions on the respondent's notice.
Seven minutes to go.
I will seek to use them judiciously. Related points, submissions were made about the transcript relating to Sarah's position. In my submission, that goes nowhere. We know that the upshot at the end of this was that Mr. Jarvis's understanding, based on the totality of what he'd been told by Vacar, was that Sarah's adverse possession claim would not be pursued. That's based on that exchange, and it's also based, of course, on the confirmation exchange, which is expressly referenced in paragraph 130 of Mr. Jarvis's judgment, which is the one set out conveniently in Mr. Justice Bacon's judgment, paragraph 66, the one that has the really terrible transcript. So one knows where it got to at the end of the day without parsing that bit of transcript on its own. That's the first point. Second point is even if it is right that Vacar was being more front-footed about saying there might be an adverse possession defence in Sarah's name in that bit of the transcript, that is not a reason to depart from or cut down or challenge what His Honour Judge Gerald has found about what matters, which is Vacar's own rights, and what he was saying about them. If anything, it's consistent with the sort of conduct which His Honour Judge Gerald described, of Vacar being manipulative, seeking to achieve one result in the judge's mind, which he successfully achieved, i.e. there were no adverse possession defences, but along the way keeping his bread buttered on both sides to some extent. Now, in the extent that's a speculative submission on my part, but that is because what one is doing here is illegitimately going behind the judge's finding. It is certainly not appropriate to look at that transcript in isolation and say that that renders the judge's, Judge Gerald's findings perverse. And attempting to do so is contrary both to common sense and to the Volpe principles, which I know the court is very familiar with. And is picking out one favourite piece of evidence and saying, well, you know, that bit wasn't specifically mentioned, or my submission didn't need to be mentioned in light of what else was said, including paragraph 130 and what lay behind that, the references to that. And as I say, at the end of the day, it's a side show, it is Vacar's rights that matter, not Sarah's. If the court will permit me, I think those are the main points I wanted to make. I have a few very short points on the law that I can probably make a sentence at a time, picking up on particular authorities. In the Seddon case on abuse of process, my learned friend focused on the words possible but not necessarily in relation to the construction of the pleading adopted there. It couldn't in my submission be seriously suggested that the Court of Appeal in Seddon was saying one had to have a necessary construction of what was said in every single case. In the case before them, it was material as to how clear the relevant statement was, but that's partly because it was about a pleading which had gone by way of admission, not something that a court had actually relied on. You can look at the judgment and see what the court was relying on, which is our case. It's also highly material to the decision in Seddon, part of the reason why the case failed. The point failed in that case is that the position being taken on the two occasions, although there was an argument that it was inconsistent in its drafting, wasn't inconsistent in its substance. There was nothing inherently contradictory about just having sued one partner first time around and then suing all three of them second time around. At the end of the day, what amounts to a clear inconsistency and what its impact will be depends on the facts in each case. In relation to Aldi, Pictall and the court's approach, the response to that is the response which as I understand, was given in somewhat different form both by my Lady Justice Asplin and by my Lord Justice Zacaroli. Pictall is about a different species of abuse where what one is looking at is tantamount to a single rule about circumstances when you issue a claim form. That's apparent from the way it's described by Mr. Justice Mann in that case. Our type of abuse is different and is like an Aldi one. It's a look at all the facts type. On adverse possession, I think almost the entirety of what I have to say is said this morning and in our skeleton argument. At the start of Malone and Friends submissions on that, he gave a helpful overview of the current position under the 2002 Act, Schedule 6, and how the law now works. I didn't mean to intend to convey this morning that adverse possession has dropped away or is a dead letter. Of course, there are circumstances where it's still live, and boundary disputes, another classic familiar to every Chancery practitioner, where adverse possession will live on forever because it's the only way to solve many of those cases. But it is material to some extent that the regime on any view now is much less generous than it was with the adverse possessor before 2002. Parliament's view as to what is appropriate as a matter of policy in the case of registered land has clearly changed very dramatically. Now, of course, the court has to apply the law as in force at the material time in this case, and we're dealing with a case where the time is said to have run already before 2002. But I do say that when one looks at, when my learned friend makes submissions about the policy of the Limitation Act and how Mr. Jarvis must necessarily have applied it in 2011 or what this court must necessarily do now, one can't entirely close one's eyes to the reality that we now live in a world where the approach to that policy is a somewhat different one. is much less generous to the squatter.
Thank you.
I think that is probably all that I have to say that I haven't said this morning on written submissions. Subject, of course, to the court. I think you know what I say about the remainder of the adverse possession points.
Yes, that we have that in detail from you this morning. Thank you.
I'm very grateful.
Thank you very much. Well, thank you both very much, and those sitting behind you and who've done all the preparations. I have to say, absolutely exemplary bundles, for which I think we're all very grateful, when this has been one of those rare cases where you've had vast numbers of authorities which you've actually been referred to. So, you won't be surprised to hear that we're going to reserve our judgments. We can't tell you precisely when they will be handed down. We're very conscious that for this family this has been going on far too long, and we will endeavour not to add to their misery longer than absolutely necessary. Please could you remind all the parties about the terms of the embargo, which will appear at the top of the draft, and then you can send in the normal way any typographical or minor factual errors. It's not an opportunity to re-argue, as you're both very well aware. I hope everything else can be dealt with in writing. Any difficulties outstanding we'll deal with on paper, and I would hope you could agree a draft order at the end of the day. Thank you all very much indeed. You've covered a great deal of ground in a very tight timetable, and we're very grateful.
Thank you, and I'm sure we're all very grateful for sitting late on both days.
Oh, thanks. Oh,
Just give me a moment to put everything in. Let's see now, that's great. Let's take that. We did, yes.